It is claimed that the Constitution of the Islamic Republic of Pakistan is Islamic when the people see it in action. However, through its interpretation by the courts, they start having doubts. This is when questions about the Islamic nature of the Constitution arise. The questions are raised mostly in religious circles, but scholars in the legal fraternity sometimes join in and express doubts too. We believe that mere insistence that the Constitution is Islamic does not sound very convincing. The interpreted Constitution must make one feel that this is Islamic law in action. Merely writing down text does not help. Each and every article of the Constitution must be justified through the principles of Islamic law. The principles of political organization so identified will then apply not only to Pakistan but to the entire Muslim world. A modern state is expected to deal with a mass of social problems. To carry out these functions, the state must have agents or organs through which to operate. The Constitution is a document that deals with the appointment of these agents or organs, lays down their functions and powers, and describes the relations of these organs among themselves, along with their relations with the citizens. In Islamic law, this is the organization of the wilayat, or the authorities within the Islamic system, which in turn is derived from principles laid down in the Quran and the Sunnah. A constitution sets limits on the power that governments can exercise, and it also lays down the manner in which such power is to be exercised. The Constitution, then, is a standard or a benchmark against which all actions of the government are to be performed and measured. There are many definitions of the term Constitution, but the one preferred here is by Barnett, that the Constitution is a living, dynamic organism which at any point in time will reflect the moral and political values of the people it governs. In short, the Constitution is a document that shows how a people wish to be governed, what values and rights are dear to them, and what their idea of justice is that they wish to implement. A constitution, however, is not born in a day. It represents the history of a people, their political system, and their values as they have grown over time. It is the struggle of a people to achieve what is dear to them. These definitions make it obvious as to what kind of constitution the Muslims of Pakistan must have for governing themselves. Their attempt to flourish on the basis of borrowed traditions, history, values, and culture is doomed from the start. The general features of the Constitution of Pakistan, 1973, may be summarized as follows. First, it is a written constitution. Pakistan has adopted the parliamentary form of government with a written constitution. The written constitution is the supreme law of the land, and it can give rise to judicial review of statutes, leading to the striking down of those that are repugnant to the Constitution. Second, the Constitution is based on a federal system. Pakistan is a federation with a federal government and provincial governments of the federating provinces. The provinces enjoy considerable autonomy. A question may be raised here as to whether the provinces, through a compact, have given rise to and brought together the Pakistani people. Third, it is somewhat rigid. The word somewhat means that it is difficult to amend it, but it is not as rigid as the United States Constitution, for which a very complicated procedure has been provided. From another perspective, if the Constitution's text can change easily and frequently, the question arises whether such a constitution will be taken seriously, for it will be reduced to the level of ordinary statutes, which can be amended with a simple majority. Fourth, it is based upon certain organizing principles. The Constitution is based on certain organizing principles, like those of democracy, the rule of law, the separation of powers, federalism, and ministerial responsibility. The principle of parliamentary sovereignty is not followed in Pakistan. Fifth, constitutional rules are all contained in a single document. All the principles and rules that are considered fundamental for running the government or affairs of the state are contained in a single document called the Constitution of the Islamic Republic of Pakistan, 1973. Where a fundamental principle has been stated in the Constitution, the details may appear in a statute. Sixth, the sources of the Constitution are also divine. The Constitution of Pakistan acknowledges the Quran and the Sunnah as sources of the Constitution and of the law as well. This is supported by the Objectives Resolution, which is now part of the Constitution. It is a stated principle of the Constitution that no law will be made that is repugnant to the injunctions of the Quran and the Sunnah. Seventh, the Constitution follows the idea of responsible parliamentary government. Parliament, through its legislative power, exercises some form of control over all the branches of government. In addition to its supreme lawmaking power, Parliament supervises the general conduct of the executive. This is done through its ministers, and then tries to check them through the parliamentary committees. Parliament also reorganizes the system of courts without interfering with litigation. Eighth, independence of the judiciary from the executive. The appointment and dismissal of justices of the higher courts has come more and more into the control of the courts through different procedures, thus ensuring independence of the judiciary. Ninth, the Constitution upholds the separation of powers. It is claimed that the system contemplated by the Constitution works based on the separation of powers. Its full implication has not been realized yet. 10th, the Constitution guarantees certain fundamental rights. These are justiciable, and people can go to courts when such rights are violated. In order to assess the nature of the Islamic Constitution of Pakistan, we may now comment on the various models of constitutions of other countries that have Islamic content. In Saudi Arabia, the Quran itself is the constitution. It is not clear whose interpretation of the Quran will apply. Will the statutes be struck down if found offensive to the Quran? Is a form of government implied by the Quran presidential, parliamentary, monarchy, or another? In Egypt, Sharia is the principal source of legislation. This was also the position taken by the 2012 draft Constitution of Libya. A Chief Justice of the Constitutional Court of Egypt was heard assuring the audience at Harvard Law School that only the definitive or qat'i rules of the Sharia will be accepted. Let us hope this is not true. The Constitution of Iraq provides that no law contradicting established provisions of Islam may be enacted. It is not clear what the term established means in this context. Does it mean definitive? The Afghan Constitution states that no law shall contravene the provisions of Islam. It also states that all gaps and vacuums shall be filled through Hanafi law, which is the law of the majority there. The following Islamic provisions of the Constitution of Pakistan may be said to restrict the authority of the Parliament. Article 1, Pakistan to be an Islamic Republic. Article 2, Islam to be the state religion. Article 2A, principles and provisions set out in the Objectives Resolution to be an effective part of the Constitution. Articles 31, 37H, 38F, and 40. Principles of Policy of the State, Articles 41.2, 62D, 62E, and 62H. Qualifications of M&As, Article 2, 27 to 230. The Council of Islamic Ideology, Articles 203 Section A to 203 Section H. Federal Shariat Court. The previously stated Islamic provisions are supposed to have the following impact. No law can be made contrary to the injunctions of the Quran and the Sunnah. All such laws will be subjected to the repugnancy test in accordance with the provisions of the Constitution. In other words, the Parliament cannot make laws that are un-Islamic. It is to be noted that in the same way, it has been stated that a law made in derogation of fundamental rights shall be void. To give effect to this requirement, The fundamental rights are enumerated and made part of the Constitution. If no law can be made contrary to the injunctions of Islam, then are these injunctions part of the Constitution? It is obvious that there are too many injunctions, and they cannot all be mentioned in the Constitution. These provisions are supposed to convert laws into Islamic laws in two ways: operation on existing laws and operation on new or proposed laws. Article 227, Section 1 requires that all existing laws shall be brought in conformity with the injunctions of Islam, and no law shall be enacted which is repugnant to such injunctions. For the existing laws, the Council of Islamic Ideology has already submitted its reports as required. The Federal Shariat Court has struck down certain laws and approved others. The issue of riba has also been decided now, and only a few more remain pending. For new laws, Article 229 provides that a proposed law can be referred to the Council of Islamic Ideology for guidance. But Parliament may go ahead with the enactment even before the answer is received if the public interest so requires. This is stated in Article 230, Section 3. The legislatures, federal or provincial, are not bound to refer new or proposed enactments to the Council of Islamic Ideology, and they usually do not. Laws are almost always made by the legislatures without consulting the Council of Islamic Ideology. Such laws may be questioned in the Federal Shariat Court. We have now explained and highlighted some of the salient features of the Constitution of the Islamic Republic of Pakistan, including the Islamic provisions. In the videos to follow, as we proceed to examine the important articles of this Constitution through the eyes of Islamic law, we will be able to assess how far Islamic constitutionalism is visible in the Constitution and how far this Constitution is Islamic. It will also be our endeavor to show in a positive way how far some of the provisions of the Constitution may be compatible with the Sharia. As compared to this, courses in law schools undertake a study of the history of how the judges, especially the judges of the Supreme Court, have read the provisions of the Constitution and applied them to cases over the decades. The idea is that their decisions in the past will enable us to predict how the judges will decide in the future.